History of human politics often begins with a promise. Power will serve the people. But that same history, if examined closely, often ends with a far colder truth. Power, if not limited, will gradually begin to serve itself. And the story of the Supreme Court of the United States begins with that fear. Part 1. The Fear of Power, the Founders' Dilemma. After gaining independence from the British Empire, the founders of America did not simply celebrate victory. They worried they had just overthrown a king, but now they were about to create a new government, and that new government would also have power. The greatest question was not, how do we win, but how do we win without creating a new tyranny? In Federalist Paper number 51, James Madison wrote a famous line, open quote, "First enable the government to control the governed, and in the next place, oblige it to control itself." Close quote. That was not naivete, it was clarity. The U.S. Constitution was not built on the belief that human beings will always be good. It was built on the assumption that human beings have limits, and when power meets opportunity, those limits can be bent. Part 2. Separation of powers, but still not enough. The Americans created 3 branches of government: legislative, Congress; executive, the president; judicial, the courts. Each branch has its own strength. Each branch has its own potential for abuse. They clearly understood 3 dangers. 1. A beloved president can become a king. 2. A Congress representing the majority can crush the minority. 3. A wave of public passion can push the entire system away from principle. Separation of powers was the first step. But one dangerous question remained. If the Constitution is only a document, when politics tries to bend it, who will say no? Part 3. The idea of a gatekeeper outside politics. In Federalist Paper number 78, Alexander Hamilton described the judiciary as the weakest branch. No army, no budget, no power to pass laws, and yet it holds a special authority to interpret the Constitution. From that emerged a core principle. The Constitution is the fundamental law, and there must be an institution independent enough to protect it. That institution is the Supreme Court of the United States. Judicial review, power without a sword. The Supreme Court holds no sword. It controls no treasury, but it holds the ultimate question. Is this constitutional? If the answer is no, political power, no matter how strong, must step back. This authority was firmly established in 1803 in the historic case Marbury v. Madison. Chief Justice John Marshall declared, "The court has the power to invalidate laws that violate the Constitution." From that moment on, Congress was no longer the absolute highest authority. The Constitution was supreme, and the Supreme Court became its guardian. Part 5. Why 9 justices? The Constitution does not specify the number of justices. At different times, the court had 6, 7, even 10 members, before settling at 9. 9 represents a balance, small enough to maintain coherence, large enough to prevent individual dominance, diverse enough to encourage real debate, a structure small in number, but supreme in principle. Part 6. The appointment process. Checking power with power, or worse. The President nominates, the Senate confirms. No one is allowed to choose the person who will check them alone. Each Senate confirmation hearing becomes a public philosophical debate. How does the nominee understand liberty? Do they see the Constitution as fixed text or a living principle? Where do they draw the limits of power? This is not merely selecting a person. It is choosing the lens through which the nation will view itself for decades. Part 7. Near lifetime appointment. The price of independence. Under Article 3 of the U.S. Constitution, federal judges hold office during good behavior. No term limits, no re-election, no reduction in salary. Why? Because if judges had to campaign, they would listen to the crowd. If they feared losing their seat, they would listen to politics. Lifetime tenure is not a privilege. It is armor, so they can say no to power. Part 8. Checking the president, even in crisis. In 1952, during the Korean War, the president sought to seize control of steel mills. The case reached the court in Youngstown Sheet and Tube Co. v. Sawyer. The court ruled the president did not have that authority. The message was clear. A crisis does not create new powers. Executive power cannot expand itself at will. Part 9, checking Congress. Protecting the minority, a law supported by the majority, can still be unconstitutional. In 1954, in Brown v. Board of Education, the Supreme Court declared racial segregation in public schools unconstitutional. Many states invoked tradition. Many politicians resisted. But the court affirmed, equality does not depend on geography. It was a moment when America corrected itself through the Constitution. Part 10, no one above the law. In 1974, in United States, Nixon, the court ordered the president to release tape recordings during the Watergate scandal. No office is immune from the Constitution. The most powerful office in the nation must still bow to principle. Part 11. Protecting the smallest rights. Freedom does not die in one dramatic battle. It dies in small restrictions. In 1971, in New York Times Co. v's United States, the government sought to prevent the press from publishing classified documents. The court sided with press freedom, because if national security can silence dissent, one day the Constitution itself will become only a symbol. Part, why does this system sustain a republic? A nation does not collapse because it makes mistakes. It collapses when it has no mechanism to correct them. The Supreme Court is not perfect. Some decisions are controversial. At times, it faces criticism. But what matters is this: there is always a place where power must answer. There is always a boundary that cannot easily be crossed. There is always a constitution higher than election cycles. Conclusion: 9 seats and the original promise. The Supreme Court does not govern America. It does not command the military. It does not control the budget. It does not campaign for office. But it protects something greater. It keeps the Constitution from becoming a slogan. It ensures that power remains strong, but limited. It allows the Republic to endure crises, divisions, and storms without drifting away from its original promise. 9 seats, black robes, a document written in the 18th century, and a principle that still lives today. No one stands above the Constitution. That is not merely a structure of power. It is how a nation protects itself from itself. Thank you for taking the time to watch this video. If you found it helpful, don't forget to leave a comment and watch more videos on the channel to support it. Goodbye, and see you in the next videos.